To show purpose. Do you agree with his answer on that?
Hi, everybody coming in. I kind of timed this out wrong, so I'm thinking it's going to start closer to 10:30. However, we will just go through some SCOTUS updates for now. Right now, Sony and Cox are still arguing. It's been a little interesting this morning, but we should be hitting our asylum case pretty soon. If you want to swipe out and come back at 10:30, that's totally cool. I am just going to look at some updates. We did have some per curiam opinions drop that were not oral arguments at all. Nothing we've heard argued before the court. I can go through those. I'm sorry you have a little bit of sound in the background, but I'm listening to Sony and Cox argue right now. Give me 1 second. Opinions of the court. We had 2 per curiam opinions drop. None of these made it to oral argument. There is Pitts versus Mississippi. Ordinarily, the Sixth Amendment's Confrontation Clause guarantees the defendant a face-to-face meeting with witnesses appearing before the trier of fact. In child abuse cases, however, that rule sometimes gives way. Consistent with the Sixth Amendment, a court may screen a child witness from the defendant when necessary to protect the child from trauma that would be caused by testifying in the physical presence of the defendant, at least where such trauma would impair the child's ability to communicate. Still, before invoking this procedure, a court must proceed with care. It must hear evidence and must make a case-specific finding of the requisite necessity. Simply pointing to the state statute that authorizes a screening, even one premised on general findings of necessity, will not suffice. Because the Mississippi Supreme Court departed from these principles, we reverse. So that's one of the per curiam opinions that dropped. It looks like what the state did was basically said, no, we're going to do this separately, but they didn't follow the procedures, so they reversed that. In fairness, courts have a procedure that they have to follow. I hate who's going first, Hegseth, Cash, or Bondi. In this one, I have no idea. Let's see. Yeah, the petition for certiorari is granted. The judgment of the Mississippi Supreme Court is reversed, and the case is remanded for further proceedings not inconsistent with this opinion. So all they have to do going forward is make sure that they've done all their procedures to make sure that this child does not have to appear before the court with this defendant. Sorry, and the noise in the background is still Sony and Cox arguing. I did not cover this one because I hate copyright law and I just don't fucking care. But it is an interesting case. And then let's see. And then the second per curiam opinion that dropped without oral arguments was Terrence Clark, director of Prince George's County Department of Corrections, versus Jeremiah Antoine Sweeney. A Maryland jury found Jeremiah Sweeney guilty of second-degree murder and several other crimes. Sweeney's convictions were affirmed on appeal, and his bid for post-conviction relief in the state court was unsuccessful. Sweeney sought habeas relief in the federal district court, and that court too denied relief. But the Fourth Circuit reversed and ordered a new trial, relying on a claim that Sweeney never asserted. Because the Court of Appeals departed dramatically from the principle of party presentation, we reverse. So those are the 2 per curiam drops we've had. Again, none of those were argued with oral arguments. And we are still waiting on this one to pop off, but it's going to be a minute because Cox and Sony are still going at it on their copyright shit. I will be honest, I don't see the court siding with Sony only because this is just what I see. And again, I could be 100% wrong. it's very hard to say that just because they're a provider, they willingly contributed to this copyright infringement. But again, it's one of those things. And I think we have one of the Trump attorneys arguing for Cox, but we may have moved on to Sony.
I think Mr. Clement would probably say that the DMCA
Let's see. Is there anything else popping right now? But we are waiting. If you want to swipe out and come back at 10:30, that's when I think this is probably going to pop off.
DMCA equivalent for electric companies.
Oh, Comey and James. Yeah, well, they were dropped. Comey was without prejudice. They can refile that. I'm not sure on James right now. I'd have to look. I'll probably talk about those cases once they hit higher courts. That's probably when I'll get into them. But Lindsay Halligan got that boot. So did Alina Habba, apparently. That's always fun. Oh, was it both without prejudice? Okay, yeah. So they can refile them. I'll see what happens. I think Comey is definitely a case of persecution. That's my opinion. I wouldn't even say I'm a Comey fan, but you can certainly see some implications there. I may restart and come back on when this case is over because this case is fucking going, man. I thought it would be in and out, but they're getting into some complications here. I may restart at 10:30, guys. Does anybody have questions about this case? This is an asylum case, guys. This is an asylum case. What rises to the level of persecution? And so when you see an immigration judge, this is a lot of fact people are unaware of. Immigration judges are not the judicial branch. They are the executive branch. So you go see an immigration judge, and let's say an immigration judge doesn't find for you. Then you have to appeal to the Board of Immigration Appeals. Also part of the executive branch, appointed. And then if shit doesn't go your way, you can do an appeal to the Court of Appeals. However, where it becomes super problematic is that there's like a 6-5 circuit split on what constitutes this sort of finding of fact of does it rise to the level of persecution. In some of the circuits, they say that you have to use the IG and BIJ or IJ and BIA assertion that this rises to the level of persecution. What they're claiming and what frankly I believe to be true is that it requires a de novo review. I believe once it hits the appeals circuit, they have the right to consider whether this rises to the level of persecution. And since it is such a messy circuit split, it's going to be interesting to see where they'll go. I really loved, so their cert petition was good. Man, they were doing throwbacks to Alito, Scalia, very crafty in the way that they worded this. They quoted Loper Bride in here. They quoted a few other cases where the court was like, you don't get to do this. You have to, the executive doesn't get to make this choice. However, because immigration is a very exclusive purview of the executive branch, it'll be interesting to see where it goes.
Up here, we had
Hold on, let me see where they're at.
more targeted approach. I don't think, how far would Grokster get you?
Ugh.
Grokster wouldn't get me very far
Anyway,
in this case because
yeah,
this
we're gonna see what happens.
rested its holding on inducement.
I think it'll be
If you look
interesting.
at the briefs in Grokster, if you look at the oral argument and what the lawyer for Grokster himself
But this,
told the
I'll read you some of like what occurred in this guy's case.
federal judge now.
So
Mr. Toronto told this court
petitioners Douglas Humberto, Urias-Orellana, Sara Elania Gomez Mia, and their minor child are citizens of El Salvador. They fled their home country after an extended campaign of terror against their family orchestrated by a sicario, which roughly translates to hitman for local drug lords. The trouble started in 2016 after an argument between the sicario and Douglas's half-brother Juan over a romantic relationship between the sicario's mother and Juan's father. Enraged, the sicario shot Juan 6 times. Juan survived, but he suffered severe injuries from the shooting and is now wheelchair bound. The shooting apparently did not placate the sicario, who vowed to unalive Juan's entire family. The sicario turned his crosshairs next on another of Douglas's half-brothers, Humberto. The sicario ambushed Humberto in a secluded alley, shooting him 9 times. Humberto, too, miraculously survived. Douglas feared for his family's safety, so they fled from their hometown of Sonsonate to, I'm gonna butcher this, but Cojutepeque, I think is the name of it. There they remained in hiding for about a year. Believing the worst to be over, Douglas and his family moved to another town in El Salvador called Claudia Lora, to be closer to their family. But the sicario got wind of their new location within a few months. Soon afterwards, 2 masked men brandishing weapons approached Douglas, demanded money, and warned Douglas that they would leave him like his half-brothers and possibly kill him if he did not cave to their demands. About 6 months later, Douglas again was threatened at gunpoint by masked men, warning that they would kill him if he did not pay up. Fearing for their lives, Douglas' family moved again within El Salvador to Cara Sucia. They successfully remained in hiding there for 2.5 years, but it did not last. In December 2020, Douglas and Saria returned to visit Douglas's family in Sonsonate, where Douglas was confronted by 2 masked men on a motorcycle. They threatened Douglas, assaulted him by striking him 3 times in the chest, and warned him that they would kill him if he did not pay them. On their journey home, Douglas noticed 2 men on a motorcycle, who he believed to be the same men who beat him, following him to Cara Sucia. Fearful that Cara Sucia was unsafe, Douglas's family returned to Claudia Lora, but there Douglas noticed the same men who had assaulted him were patrolling Claudia Lora. Apparently in search for him, Douglas later overheard 2 men asking a store employee if they were newcomers to the area and where they were located. So the family fled El Salvador and came here. That's a crazy, crazy, crazy story. However, where it becomes problematic in terms of immigration is that past persecution or fear of future persecution. He never reported them to police. That becomes problematic because part of it is that the part you're having to prove is that the government refused to control them. If you never reported it to police, and I agree, there are millions of reasons you wouldn't, that could be super problematic, but unfortunately it doesn't matter in the court because you never reported them to police. In their purview, you never gave the government a chance to take any action. This is a interesting case. We're gonna see where it goes. Hopefully it'll freaking start soon because I hate copyright law. Fucking bullshit. Essentially, Cox is trying to say, hey, we're just the provider here. We're not pushing that people infringe on people's copyright. Sony's saying, nah, we told you and you didn't do anything. How far does it go? I don't see the court siding with Sony, but I've been wrong before.
Construction kind of formulation to get the purpose. So can you deal with
Oh, shut up, Kavanaugh.
copyright case law more generally?
I'd be delighted to. And the copyright
We
law
shall
goes
see
all
where
the
it
way back
goes.
to the Harper case in 1886.
Does anybody have any questions? Please put them in the chat. While I was reading and stuff, I wasn't able to see them, so.
Critical aspect of copyright secondary liabilities as it's developed over
Oh,
the
it's
years.
going.
And I think it's important to understand that, yeah, you're right.
It's going.
Grokster, as I tried to explain, didn't focus on material contribution, but that's because the
Oh,
knowledge
for
is
fuck's
specific
sake. If they say
information.
Grokster
It's
one more
essentially
time,
designed to
I'm
provide
gonna
product.
lose
Now,
my
some of it
mind.
actually does talk a fair
I
amount
just hate
about
that name. I don't know why Grokster bothers
and what
me,
it
but it's
talks about
fucking
is-
stupid.
it says a couple of things.
It is an important case in this instance, but it just,
makes clear
I don't know,
the
it just
things
gives me
make
that,
body of case
what,
law inapplicable, and it talks about the dance hall cases and a whole bunch of
Oh.
cases. Those aren't applicable there because there's no ongoing relationship, and it's sort of and so
Oh no, you're good, Chris, because I'm still waiting on this bitch to pop off. They're arguing, Cox and Sony are arguing it out over copyright law. Only I set this at 10 instead of 10:30, and then didn't realize
no way.
like a dum-dum. So I may restart at 10:30. We'll fucking
It's
see.
very telling.
So if you're here, know to come back, 10:30.
Justice Stevens refers to the trademark law.
I already went through the per curiam opinions that dropped. I went through some of the background on this case. I'll be honest though, both sides have pretty good points in this. It's going to be hard to know. But I will say that the plaintiff's cert petition was a fucking banger. Like, it's good. That lawyer knew exactly what to put. Oh, you need me to go get my flannel googs? Baby, I got you. I got you.
Your position would threaten universal internet access and emphasizes the problems that are encountered when that decision and your position are applied to a university account shared by thousands of students, maybe 50,000 students, and tens of thousands of staff members or regional.
Here you go, Googs. I got you with the flannel, baby.
How your position works in that context, but maybe you can explain how it could.
So I think the way that my
But anyway, we're still waiting on this case to pop off. I may restart at 10:30. We'll see what happens.
Provides plenty of room for ISPs to handle things like multi-user accounts, fraternities, and the like.
Fuck yeah, it's 90s flannel.
Different policy under those. The way this case was litigated below, my friends on the other side, I mean, you know, that chart on page 11, that was a demonstrative, that wasn't even introduced in evidence. They didn't make a big pitch that, like, our liability should be limited to
Oh
just
my
those
God.
customers. Part of the reason is
Fuck copyright law and all your bullshit. Sony's a bunch of wankers.
810 to 811 shows that 95% of the customers covered by the 57,000 sort of customers that are part of the universe that makes up the 10,000 infringement, 95% of those are residential.
Listen, Sony and Nintendo and a few other corps are really fond of suing for copyright. So here's what I'll tell you. Don't copyright their shit. Just don't. Because you're fucking us all when I have to hear this stupid bullshit litigated out in court. Please leave their crap alone. Please.
The university is supposed to, under those circumstances, the ISP is supposed to sort of have a conversation with the university. Now, the ISP policy to the university says you can't use this service or allow your service to be used for copyright infringement. So that's
So, yeah, all right.
Yeah, they're trying to say that, like, the service provider didn't do enough to stop the copyright because they were still providing services to the people doing copyright. Some of these plaintiffs are like colleges, right? Colleges providing Wi-Fi.
1,000 students and another 1,000 students.
I would say
I just don't see how it's
that presents an extremely problematic issue, and that first of all, you're inferring some sort of like liability on the company when they're not the ones doing the copyright. It's like some sort of secondary liability. And then you're also saying, oh, well, if these fucking students, these 18 and 19-year-olds living on a college campus keep copywriting shit, you have to cut them off. Why? Like, I'm sorry, no.
Precisely because they don't want to be in the position of having guests that are staying there largely so they can sort of upload and download copyrighted works.
Hopefully this will start soon, though. I'm sorry, guys. I scheduled this at 10, and I didn't know if my live event would stay there, so this is where we're at.
I don't think it would be the end.
Hopefully they'll shut the fuck up soon, though.
Service at a speed that was sufficient for most other purposes, but didn't allow the students to take.
I know, Googs, you need to chase your cows around and be like, do you want to hear about my Lord and Savior, Jesus Christ?
The university. We've sued Cox, we've sued Granday, and I think it's worth, in thinking about the consequences of this case, I think it's worth taking a quick.
No, Toby, I'm well aware of that. I'm saying that the service provider, I'm saying they have every right to sue the individual doing the copyright. I have no issue with that. I'm saying that some sort of like secondary liability through a service provider is a little wild to me.
The hospital or that sort of thing. I mean, if we decide the case in your favor, you could. You're just saying you wouldn't.
I don't think that we could. We certainly couldn't readily. And again, I think that there's.
Let's see what's popping on Twitter. Hold on.
First of all, you know,
Let's see what we got.
different position. They're kind of like more.
Oh yeah, if you're unaware,
And there's no.
they said nah, Alina Haba. Let's see what happened. Yeah.
In 1998, on the role.
I reposted it earlier this morning.
Create an incentive for
Where's my
to
page?
adopt reasonable measures, and I think that would certainly
So,
eliminate measures that treat.
The Third Circuit rules Haba is disqualified as U.S. Attorney in New Jersey, and she can't hold the role as an acting either. Haba is not the acting U.S. Attorney for the District of New Jersey by virtue of her appointment as First Assistant U.S. Attorney, because only the First Assistant in place at the time of vacancy arises automatically assumes the functions and duties of the office under the FVRA. Additionally, because Haba was nominated for the vacant U.S. Attorney position, the FVRA nomination bar prevents her from assuming the role of acting U.S. Attorney. Finally, the Attorney General's delegation of all the powers of a U.S. Attorney to Haba is prohibited by the FVRA's exclusivity provision. Therefore, we will affirm the District Court's disqualification order. That dropped a couple hours ago.
Is not only what gives the ISPs an incentive to behave responsibly.
Yeah.
It's also
This is all about
gives them an incentive to come to the table.
who gets to like determine the final word on persecution for asylum seekers. Do bureaucrats' definitions hold, or can the court engage in its own analysis? And I kind of have covered of this a little bit. We're waiting for it to start. We're still listening to Sony and Cox fucking pissing contest about their stupid fucking shit. But if anybody has questions, please drop them in the chat. It's better for me to answer them now than to answer them while they are talking. Because as you all know, if you have been here before, I cannot pause oral arguments.
Right now, Cox is agreeing to participate in this notice system, but why doesn't Cox just walk
So,
away from the deal
it's a good
and
time.
say, you know, we just don't care what our users are doing on our infrastructure.
Like, this is a big thing that they're arguing about. Let me find it real quick.
Safe harbor, because without knowledge, they're not going to have liability.
I think there's a concept in the law called willful blindness, Your Honor, and I think willful blindness would satisfy the common law standard for aiding and abetting. And so somebody can't, if you have like the Hammer of the Month Club and keep on giving it.
So this is a big thing that they're arguing about. The scope and standard for review. Except as provided in paragraph 5B. The Court of Appeals shall decide the petition only on the administrative record on which the order of removal is based. The administrative findings of fact are conclusive unless any, reasonable adjudicator would be compelled to conclude to the contrary.
But to go back to Justice Thomas's question,
But is it a fact?
enacted a
or is it a question of law? Is the definition of persecution, is what constitutes persecution a question of fact, or is it a question of law? And that's why there's such a huge circuit split on this.
Congress debate issues like the ones you and Justice Alito were discussing. Why shouldn't that be a kind of tiebreaker here of letting Congress solve the issues that you're raising?
Well, I think it shouldn't for a couple of reasons. First of all, I don't think you're dealing with...
Oh my God, I really wish people would stop asking me to co-host. It's so annoying.
Copyright Act, and the question is to what extent
Yeah,
does
but
it reach...
is this a fun, like, I mean, really,
And I think
I would drop this in the chat. Is this finding of fact or is this finding of law? What does the law say? Literally, right here. The they don't say anything specific rising to persecution. That's the whole problem, is that, like, while they say the Court of Appeals shall decide the petition only on the administrative record on which the order of removal is based, the administrative findings of fact are conclusive unless any reasonable adjudicator would be compelled to conclude to the contrary. But this is the problem. If you're talking specifically about persecution, when the immigration judge or the BIA both review this, right? And they're like, yeah, there wasn't persecution here. Is it because it was a finding of fact? Or does it come under a question of law? That's the whole issue. That's where it's coming up. Does this preclude a justice from doing a de novo review of the circumstances that led to the denial?
There was no vicarious liability because they didn't make money off of the infringing, but there was material contribution liability. So that's the evolving passing. And so I think
I don't know if Travis and Taylor will get. I really could not care less.
a provision that I only came across over the weekend.
I'm not a Swiftie, so I really honestly would not freaking know.
Says that the anti-circumcision
Taylor Swift wanted to impress me. She could, like, you know, maybe do anything. Anything relevant. Anything that I would care about.
contributory infringement in the code.
Like, people always ask me who people are. They're like, have you heard of this influencer? Have you heard of this person? Have you heard of this so-and-so? The answer is almost always no. Is it shit? Are they on a podcast, like a legal podcast? Do they do political TikTok? Or are they like on AM radio? I probably know who they are. Beyond that, I don't know who any of these motherfuckers are. Except for Chit, because I love Chit. Chit is the shit.
The cautionary tale, maybe to take account of where
We're still waiting on this motherfucker to start.
for example, I mean, the Central Bank of Denver, as you well know, the court refused to imply any 80-minute
I do listen to AM radio, Googs.
act, and so Sony sits in some tension with our law right there. And
Well, but that was...
isn't that a flag on the field for us?
I mean, look, the Central Bank of Denver, you already have like a made-up cause of action, and the question is, do we make up a bow?
I just really don't think they're going to side with Sony on this one, guys. I really don't. I don't think that this is going...
Is okay too bad?
No, I really do think...
I don't see it.
And the court's precedents, which
It just doesn't jive with, I think, like,
too late to sort of say this is all like
the sort of normal things I see with this court.
I accept that, but it doesn't
Do it, lady!
caution here.
On your birthday!
Look, it's always good to have caution, but I would look not just to the patent law, I would look to the trademark law.
And as always, I cover up all the male justices on the panel, because fuck them, that's why. And I leave the ladies.
First Circuit did, right? It didn't say, did you have specific knowledge of individual users who are infringing, and did you do something special?
Oh my god, Alito, shut the fuck up!
Know that they would, in fact, infringe. We'd have to reverse under your standard too.
I don't think so, but
Fiddling today. That's not what they held.
Oh, it's kind of heating up. Hold
I
on.
just read this Fourth Circuit case differently. I read the Fourth Circuit opinion by Judge Rushing to specifically say the substantial certainty test is what's being applied and what
This
makes
is
this
Sony,
state
by the way.
Gross. And we've got an amicus brief from some intellectual property scholars that say that was wrong.
Well, you get a brief from some other intellectual property lawyers,
fair enough.
professors who say that's exactly
but they
right.
did do it in gross rather than say, I have knowledge of a
I
specific
promise we're
student
waiting for this one to start. We're hearing the end of
at
Cox versus
Georgetown
Sony.
University. That's not what happened in this case.
No, but I actually think it is, but it's a little bit opaque in the opinion because this case.
A little bit opaque.
No, but it's opaque for a very specific reason. Because, this case sort of piggybacks on the earlier BMG decision. And in the BMG decision, the Fourth Circuit says that once you have knowledge that the
This is Cox versus Sony right now. We're waiting on the one I actually want to hear to start, but this one's pretty interesting. I don't see them going with Sony.
Well, I think the customer did it as to the bill payer, the account holder, which of course is the same unit that Cox uses when there's non-payment.
I appreciate
when Cox doesn't get payment from grandma, they don't.
That isn't the common law, even under the
Oh, he's not arguing with him.
Is the common law still? I don't think you need.
Of people, I know somebody in this group of people was involved, and I did nothing. That's not substantial certainty.
So with residential customers, I think it is. But in all events, that was ruled on in summary judgment in this case. And then what the Fourth Circuit did, and I don't think you can read this.
Yeah, that's the reason they're hearing your case, buddy, because fucking they don't, something's wrong with the decision.
Knowledge to the specific customers.
Mr. Clement, can I just bear down a little bit on your testimony?
Yeah, I got you. So are you talking about the case here, or are you talking about the case we're listening to? Because right now, two different things going on. What's happening right now is Sony, or Cox v. Sony. Cox v. Sony is an interesting copyright case where Sony's saying, nah, bitch, we told you these motherfuckers were committing copyright infringement and you didn't ban them. And Cox is saying, these are like campuses, user dwellings, campuses, hospitals, shit like that. What are we supposed to do? Cut off the fucking hospital because some of their patients are like fucking copyright infringing, or their employees? Like, Cox is on they totally are like, if you want to sue the individual doing it, go for it. But why are you telling us we have to take their service down? And Sony's like, no, you didn't do enough. That's an interesting one. This one, though, oh my God, oh my fucking God. So this one really comes down to, is what rises to the level of persecution a question of fact or a question of law? Now, so when you go before an immigration judge and the BIA, that's the executive branch, they make this determination. There's a circuit split over whether judges should, in the appeals court, once it reaches an appeal, should be able to do a de novo review where they look at the factual matter constituting your claim of persecution, or can they only rely on what was presented in the decision of the BIA? So that's where it gets problematic. I think it's a question of law and fact.
The copyright laws, the trademark laws are a little bit different.
Hello.
I think they do think that when you are providing the means of infringement to somebody,
hi Thor,
that's pretty easy to show that is material contribution, substantial assistance. And so if you're looking to distinguish the FedExes of the world, the electrical companies of the world, I mean, agree with Mr. Stewart. I thought he did an excellent job of sort of parroting what my answer would have been with respect to the DMCA. But I would also say, there's a difference when you're providing the means of infringement, which is what the ISPs do in these cases. That is going to be material contribution if you're doing it with knowledge of specific customers and what they're likely to do. And that's true in the trademark context as well.
Okay, but are they providing the means of infringement? I mean, they're certainly providing a service. However,
pharmaceuticals, and that's where this court said, yeah, there's liability.
I think that this is above the board in terms of it's sort of a secondary liability more than it is that they are a direct contributor.
Manufacturer, and it provides guns to dealers, and it knows to a certainty that there's a specific dealer that's a bad apple dealer that's passing this on to Mexican drug traffickers. is the manufacturer then liable for all the harm that causes?
I mean, there was like a separate question of proximate cause in that case that this
Right.
court didn't reach, and I don't know the answer to, but I think, you know, and I think there were questions at oral argument about red flag dealers, and if you had specific knowledge, you were providing them.
I
to
think
red
they're
flag
questioning
dealers. I think that
Sony
would
pretty
satisfy,
hard.
the intensity,
I
at
don't
least
see them
common law.
upholding
Again,
this.
all of
I
the
just don't.
Details of the PCLAA or whatever it is that was at issue.
And I'm
So
sorry.
don't
I know I promised y'all the asylum case. I promise it's coming.
But
It's
but
coming.
But I do think that with respect to the common law intent, that would be satisfied.
What about willfulness? Can you speak?
Oh
to
my
the
God.
Argument that willfulness here requires that the defendant understand that its own conduct is unlawful?
So I think they're wrong about that. I think they're wrong about that for reasons that are textual and also reasons that have to do with kind of the common law and the way that it treats aiding and abetting or secondary liability. So if you think about the common law, if you have aiding and abetting, then you are essentially on the hook for the consequences of the mens rea of the person you're assisting and your own sort of.
Okay, Goose,
mens rea
thank you.
beyond
Oh,
aiding
guys,
and
if y'all
abetting
can
doesn't
just tap
count.
the
So
screen,
if
it
I
helps
aid
so
and abet
much. I'm
a
sorry.
first-degree
I
murderer,
promise
I
this will be
would-
on as soon as this
either
one
criminally or
is
civilly,
over.
I'm
We're
on the
just
hook
listening to
for
the end of it.
the first-degree murder.
Sony's over
And
here fucking trying to
whereas
dunk
if I
on
aid and
Cox,
abet,
but
all the
I
conduct is exactly the same.
really,
And
really,
I aid and
really
abet
don't
somebody in
feel like the
manslaughter,
Supreme Court is going to
consequences are
side with
different. And then if you
Sony.
look at the text here, the relevant
I
text
could be
is
wrong
Article
though, and
4
I
of the
have been
Copyright
wrong
Act. It
before.
actually
I
doesn't
hate
focus
copyright
on
cases,
the
so
mental
that may be
state
the reason.
of the
It's a lot of
infringer.
really
That's where the
specific law that I
infringement was
just
willful.
don't
And
give a
of course,
fuck
in this
about.
context, it's the direct infringer who's doing the infringement.
I don't steal people's shit. I don't copyright fucking anything. So that could tell you why.
We are being put to two extremes here. The other side says there's no liability because we're just putting out into the stream of commerce a good that can be used for good or bad, and we're not responsible.
Thank you for the follows. I appreciate y'all. I'm trying to get to 10,000 followers because I want to be able to do these and stream it to multiple platforms, but apparently you can't do that until you get the TikTok studio. It's fucking
The only
weird.
way you can have aiding and abetting in this scenario is if you have purpose. All right? And you're
Not that
saying
I
you
don't
have
love
to
the
prove
fuck out
purpose,
of
you have
y'all,
to
because
prove
my
that there's
TikTok
something,
community,
correct?
y'all
That's
have
the
like built me
approach.
up so much. Y'all are all just so
But what
amazing, and I
Justice
appreciate each and every
Alito
one of you.
said, and some of this is that the internet is so amorphous, and what it can or cannot do, I'm not sure about. We're being told that ISPs.
We're still listening. Oh, thank you. We're still listening to Sony and Cox fucking pissing copyright contest.
Because one person in that region
So we're waiting.
continues to infringe.
Oh, come on, Sotomayor. I love her, but she's got to hurry the fuck up with these questions. I'm tired of hearing this shit.
Off the internet for the 50,000 or 100,000 people who are represented by that customer. There is a feeling of, how can I say there's a purpose to participate in that situation? Whereas I could see a purpose on single-family homes, because they're
Jesus
usually
fucking
limited
Christ.
by the number of people, and one could say
She's
if
killing
you
me.
know that it's one or two or a family of five or whatever number it is, it's small. That surely I'm materially contributing there.
Well, here's the
How do
thing.
we
What if
adopt
your
a rule
kid
that deals
did some sort of
with those
copyright
two extremes?
infringement,
So
You were unaware of it.
My frontline answer would be, I think.
and your
the
whole
takes
house
care
gets
of
cut
the
off from the
regional
internet?
ISPs, and frankly,
That would be
I'm
my
not that worried about the
question.
regional
How does this
ISPs
factor?
because
Like, I don't
if
know.
that
This
were
is
really the
just.
problem, we could go after the regional
This is a
ISPs.
shit.
You told me that there were
Whatever.
95%
Hi, Law.
of the infringements here
I'm
were
still waiting on this to
residents,
start.
So you could go after those 95%.
Right, and we could probably figure out who the regional ISP is, and then go after.
Sorry,
these
guys,
customers.
we're
That's
waiting
why
on
I'm
this,
not gonna
so
die on the
give it a
hill of the
minute.
Regional ISPs, and I think you could. I mean, material support. I mean, heaven knows this court remembers from Twitter that, by the time you look at the common law, you had 6 factors under Halberstam for what is substantial assistance. So there's clearly enough sort of, if you want to, if that's the hypo that's concerning you, then you can certainly sort of come up with a definition of material contribution that carves that out. I think
Give it to me.
I fucking
What's that?
hate
Give it to me.
copyright
I'm
law.
inviting you to help me.
and I'm
Swear to
inviting you
God.
to take my help. I mean, I don't want to it's hard to just absolutely give it away in a case where that's not the way the case was litigated. But I am telling you that, you know,
The Sony lawyer is so mad though. This is hilarious.
To adopt their position, that really is an extreme position. The DMCA and the safe harbors are
Seems
dead level.
really
If
pissy,
you
and I
carve
love
out
that.
Regional ISPs, the safe harbor is alive and well, and equally importantly, the incentives for both sides to come and to try to have a reasonable negotiation are alive and well.
Mrs. Kagan.
Can we get
Justice Gorsuch.
I swear to God.
If we were to, I think
God
Ms. Kagan's right,
damn
that
it.
our precedents speak of purpose.
Shut up.
And we have two options. One, we could take the additional
Both
step and
options
say,
suck.
because this is an
Either they
implied
have,
issue,
like, in
cause
this
of action,
context, what they've been arguing is
it's
either have
very
no
narrow,
liability
but
or
law.
they gotta cut
And
these
jail
people
law.
off.
The other alternative would be to say, it's
I
purpose
promise, guys,
and
this will
reverse
start
and
as
remand.
soon as they stop asking these fucking
And,
questions.
Mr. Malcolm invited you to say whether you thought you could prevail under that
And
standard.
as I've already conveyed, I'm not a
Well,
fan of this.
obviously, I
so.
prefer door number 3, but I would also prefer.
I understand door number
Whatever the standard is, I'd prefer a chance to pursue that, and I would think even under purpose, there has to be room for treating somebody that says F the DMCA differently from somebody that tries their level best to comply and doesn't.
Thank you.
Mrs. Kavanaugh.
You're drawing a distinction between intent and purpose, and you also, though, rely on the Henry case quite a bit from 1912 in the patent context. And there, the court said there must be
I
an
think
intent
so, Law.
and purpose. That the
I didn't look up the
article
attorneys
so
in the case
used,
because
and then
I
says that may
accidentally
also
put my
be
time
inferred
wrong on here,
where
so
it's
we're
most
kind of just
conspicuous
listening
use
to the
is
end of
one
this. I had to
which
start it at
operating
10.
infringement when
I thought I
such
put
such
10:30.
user is invoked by advertisements. So advertisement as an example of when there.
Yeah, if y'all can like and share and hand hearts and all that
Calum,
crap,
which
it
is
helps so
arguably
much. I
within a
appreciate
week
each and every
of
one of you
Henry
for
back in
sticking it
1911.
out through the end of
Calum's
Sony
the
with me
copyright case, of course.
while I yell at my
In
computer.
the reply brief, the other side points out that you ignore Calum in your brief, but Calum itself says in the copyright context, the defendant not only expected but invoked by advertisement the use of its films
Oh,
for
thank you,
dramatic
Law.
reproduction of
And
the
thank you,
story.
everybody sending the
The
hand
word
hearts and all
advertisement
that
appears
stuff.
in both cases. Henry says intent and purpose. Get your response to that.
So let me take them in turn. I mean, Henry says intent
Oh
and
my
purpose,
God,
but it
please
also
don't
says you
take it
can
in
infer
turn.
that
Just
sort of
shut all the way the
compound
fuck up.
If you know that the user is going to use it unlawfully. And like, you know, I mean, to me, you know, the right way to look at this is consistent with the
I'm not sure it says that, but anyway,
Let me
keep going.
see.
not maybe in the same line, but I think it says it elsewhere. At least that's what I take from the opinion. Maybe I'm misreading it.
Got it. Okay.
But that's certainly why we were relying on the sort of the Henry case, because you were providing it knowing it would be
Yes.
misused.
Clement Law. I just
so
looked
that's
it up.
part of the answer on Henry. But again, then you get to Calum, and Calum, yes, like obviously, if you have inducement cases, that's what advertising goes to. It goes to inducement cases. But inducement cases are, you know, historically, if you look at all of the contributory infringement cases, inducements is the smaller subset, and the dominant subset is material contribution, where you're providing material support, substantial.
So anyway, we'll take a minute and a brief break from that hot fucking mess that they have done down there. When your lawyer says maybe I misread, you'll find them saying like that or something like, you know, maybe I have like a different interpretation. Let's talk about the case that's actually coming up, which is the case I'm actually interested in. I read all this crap for y'all. I love y'all so much. But what it really comes down to is like persecution. Is it a finding of fact? Is it a question of law? When you go to an immigration judges are under the executive. They're going to listen to your case and they're going to say it constitutes persecution or it doesn't, or whatever you may be applying for. That's not the only thing they do, but in asylum cases, this is part of it. Then you can appeal if it doesn't go in your way to the Board of Immigration Appeals, and they're also under the executive branch. But then if that doesn't go your way as well, you can appeal to the federal courts, and then you start getting into an issue because the federal courts have trouble saying whether you should be using the BIA's finding of fact, or, well, the IJ, but either way, you should be using their finding of fact on what constitutes persecution, or should they be doing a de novo review of your circumstance and things like that. In my opinion, I believe that they should be able to look at it from a fresh perspective. I don't think the law is super clear that they absolutely have to observe what they said before. But again, that's just my opinion. And both sides have really good claims here. So we're going to kind of see where they go with this, because I find this fascinating. This is a huge issue right now, and people's lives are on the line. That at the end of the day, that's what it comes down to. People's lives are on the line, and I can certainly see, particularly in the case presented here, why the immigration judge said, well, you know, maybe you can't prove future persecution because you were able to move for a couple of years within this area and it not, you not have this come back up. However, I just don't know, and that's why I'm interested to see where this case goes, especially because in cases like Loper Bright, which hopefully you all remember, they're hesitant to say, well, the executive can just do what they want. Oh, law. Oh, hold on. Let me change my layout. Hey. Law? You there, bud?
Let's try that. Can you hear me?
Yes, I can.
Lovely.
Did I get something wrong?
No, you didn't. I was just chiming in. I think the one thing that's probably needs a little bit of clarity here is these are immigration judges, are not Article 3 judges. They're part of the executive branch. But they tend to, follow the rules. But this is kind of a little bit like the Wild West as far as like, are the same rules that apply for appellate review the exact same, under these immigration courts, which are, technically part of the executive branch, not the judicial branch. But also important to remember too that courts don't review questions of fact; they only review questions of law. And so a fact question is an evidence question, and the courts give that weight to whoever heard the evidence, the cross-examination and all of that, and kind of hold their view to be sacrosanct. The only thing that the appellate courts are going to review are questions of law. And here the question of law is the petitioners are arguing, well, there isn't any dispute about whether or not the events happened. Those are factual questions that there isn't any dispute of. For context, this person's family, 2 of their family members were pew-pewed by a hitman.
Yeah.
One of them 6 times and one of them 9 times, I think. And the hitman vowed to take up. They both lived.
Sorry. I know that's off the subject. I apologize.
Yeah, but then the hitman has vowed to take out the whole family, and the government has done nothing about it. So this is kind of like, it's not only asylum not only applies to persecution from the government, but persecution that the government is doing nothing about. So even if it isn't coming directly from the government and is coming from third parties, if the government has the capability to address it and is not addressing it, that also validates an asylum claim.
Case
and so,
14777, Urias-Orellana
Sorry.
versus Bondi.
No, we're good.
Thank you, Mr. Chief Justice, and may it please the court. Deciding whether undisputed facts qualifies persecution under the law involves legal interpretation, not fact-finding. Even the BIA agrees. It treats the issue as a question of law subject to de novo review. That should not change when a case reaches federal court. Indeed, the government concedes that courts must exercise independent judgment when establishing auxiliary legal principles for use in future cases. They concede that courts owe no deference in interpreting the INA's persecution standard.
It's good here.
And courts have repeatedly established auxiliary legal principles on things like sexual violence, religious persecution, economic deprivation, and beyond. But courts did not establish those principles by pondering the term persecution in the abstract. They interpreted the law by applying the persecution standard to particular sets of undisputed facts. The government wants you to hold that de novo review applies anytime a case supposedly would make new law in some sense, but substantial evidence review when it wouldn't. There's no principled way to draw that line, and this court has never tried in similar circumstances. For instance, de novo review applies to all fair use determinations made on undisputed facts and all antitrust determinations made on undisputed facts, not just some special subset. The government's contrary rule here would invite further confusion and collateral litigation. Better instead to just require de novo review and let judges get to judging. The courts of appeals are well equipped for the job. Several of them already have experience reviewing de novo the BIA's persecution determinations, and they generally review the analogous question whether undisputed facts demonstrate torture under the Convention Against Torture. The sky has not fallen. Under both the INA's text and U.S. Bank, courts should decide for themselves whether undisputed facts establish persecution under the law. Section 1252B explicitly provides for legal deference on closely related issues, but not this one. And decades of experience confirms that courts perform crucial legal work in applying the INA's persecution standard. Deference to the BIA is unwarranted. I welcome the court's questions.
Urias-Zacharias was also a persecution case, and that was reviewed deferentially. How is this different?
Because Urias-Zacharias concerned a different element of the asylum eligibility analysis. The Urias-Zacharias, the disputed issue there was about the persecutor's subjective motive, their intent. That is a classic pure question of fact. And so Urias-Zacharias was absolutely right to review that factual determination for substantial evidence. The statute before the court in Urias-Zacharias, which was the predecessor to Section 1252.
Y'all can tap and like and share. It helps so much.
Also, it didn't say the asylum eligibility determination across the board. It applied only to findings of fact. And that's what this statute says as well. So we think the government is just overreading that decision. And the government doesn't
I think you may be underreading it. There was no factual dispute in that case. Everyone agreed on what the guerrillas said to the petitioner. There was no dispute about what was said or what happened. Instead, the question was whether those undisputed facts met the standard of persecution, quote, because of political opinion. So I don't see how that's not a mixed question of law and fact, and mostly a factual question.
No, Justice Sotomayor, the dispute in that case was about whether as you said, was whether the persecution was done on account of the non-citizen's political opinion or something else. That is a question about what was in...
There was no dispute about the facts. What was said was undisputed. And so the question was, did that meet the level of because of?
No, Justice Sotomayor. The facts of the case, what was said, what was done, as Justice Gorsuch pointed out in the earlier argument, subjective intent is something that you infer from facts on the ground. So in a murder case, you might know exactly what happened, who showed up when, who fired first. But I don't think anyone would say that the facts are undisputed in that murder case if we haven't figured out whether the defendant had the intent to kill or not. And that was the same issue in Urias-Zacharias.
So what's different between what was said or done is undisputed in this case, what he was told, and the question is, did he have a fear for his life? How is that any different than what happened in Urias-Zacharias?
Because that's actually not the question in this case. This is a past persecution case. Under the INA, a non-citizen is presumptively eligible for asylum if they have suffered persecution in the past. It's not this forward-looking inquiry about whether they have a well-founded fear of persecution going forward. That's a different kind of inquiry, and I agree with Your Honor that it goes to their state of mind. It involves the calculation of a future probability, and so the case for substantial evidence review would be much stronger there. But here, where the facts of what happened to my client are undisputed. The immigration judge took his testimony as credible and true, and found that the death threats he experienced were indeed credible and menacing, but nevertheless held that under the law, they did not rise to the level of persecution.
No, but you just said there involved credibility findings. I mean, they're the sort of findings that we typically leave to a district court or another fact finder involving credibility, weighing of facts, and all that sort of things to
Alito, I think.
Determination. It seems to me a prototypical case for the BIA.
No, Your Honor. First of all, the BIA doesn't view it that way. If this were all about, determining whose testimony to believe or not, figuring out what happened, deference would be owed to the immigration judge, and the BIA would do the same. That's not how the BIA views this issue. And the reason for that is credibility is not in dispute here. My client was found credible. Whenever you have a set of undisputed facts, credibility has been resolved one way or the other. So we know exactly what happened to my client, and the sole dispute in this case is what is the legal effect of those events? Did it qualify as quote, persecution within the meaning of section 1101A42, or did it not? That boils down to a legal inquiry.
So if I agree with you, that
Y'all give law some love.
of law, to the extent that what is at issue here is the application of the persecution standard to a known set of facts, all right? I guess what I don't understand about your argument is why the statute doesn't prescribe the standard of review in this situation. I appreciate that you say in your brief that you read C, which definitely requires deference to certain legal determinations. You say, but this is not one of them, and I guess I don't understand that. The language of C says a decision that an alien is not eligible for admission to the United States is conclusive
It's not true,
unless
Goose, I'm
manifestly
sure.
contrary to the law. And in this case, I understood the agency to have determined that your client was not eligible for admission because he had not satisfied the requirements for asylum. So it seems to me to be Heartland C, and therefore the statute tells us what the standard of review is supposed to be.
No, Your Honor. C is about eligibility for admission. That's a distinct inquiry for eligibility for asylum.
I don't think so. Help me to understand that. I mean, it seems to me that there are different grounds for admission, and one of them would be because you satisfied the asylum criteria, and that was what your client was trying to do. So what Congress, I think, is covering here by this broader scope of review or standard of review paragraph is all the kinds of determinations that the agency would need to make related to the eligibility for admission.
I
This
think
is a subset
C
of that.
is a decision
No,
that an
Justice Jackson, I mean,
alien is
number one, the
not
government has not
eligible
made this
for
argument. They've
admission to the
conceded
United
that C
States is
and D do not
conclusive
apply. They do not
unless
capture the space.
manifestly
Understand,
contrary to
but
the
I'm not
law.
government, I'm reading the statute.
Fair enough, Justice
And my
Jackson.
question is, why does C, it seems to me that when you look at this provision 4, it seems as though Congress was really trying to cover the waterfront of determinations that the agency makes regarding admissibility. I mean, it says, in terms of telling the courts what you're supposed to do relative to what the agency has determined. It says, look at the administrative record, only the record that was before the agency. It says all of their findings of fact are conclusive, which I agree with you. There's no finding of fact at issue here. It says their determinations about whether or not this person is eligible for admission is also conclusive, unless it violates the law. That's the matter of law provision. They even go so far as to instruct the courts about the agency's determination with respect to the availability of corroborating evidence. I mean, Congress was really trying to nail it down in terms of what courts are supposed to do. So I guess I'm worried about looking at C and treating it so narrowly that we're suggesting that Congress somehow carved out asylum determinations and did not mean for everything the agency is saying regarding the determination of eligibility for admission to be included.
So I'll start with what I agree with in what Your Honor just said, that we do think Section 1252 establishes a reticulated scheme for judicial review that was meant to be comprehensive or close to it. Where I disagree respectfully with Your Honor is that admission somehow encompasses asylum. It does
But
not.
don't you have then the burden, if you agree with me, with the first part of establishing that Congress intended to carve out asylum and not have it be covered by this?
Yes, I do, but I think we've shown that because, again, in D, in 1252B4D, it carves out entitlement to asylum, the second step of the asylum determination, but it doesn't say anything about the first step. And again, C, and perhaps we just disagree on this, but admission is a distinct inquiry from
Isn't that
asylum.
the first step? That's the first step, and then they go to the second step.
No, Your Honor, that's incorrect. You do not need to be admissible to be eligible for asylum. Those are distinct statuses.
I think he's right on this one.
They conceded they were not admissible, but they are claiming nevertheless that they are eligible for and ultimately entitled to asylum. Those are distinct inquiries. And again, I understand Your Honor is not the government, but I think that is why the government, to their credit, did not make this argument, because that's well established in this court's case.
Neither side made that argument, right? I mean, that's applicable. You instead appealed to the background rule that questions of law are for the court to decide de novo, right?
That's correct, but we think the inference.
Okay, good enough.
Fair enough.
I wonder why you didn't make more of Elias Zacharias. The court there said, and I take your point that the court there said the finding of causation could not be reviewed except as a finding of fact. But the court also said on page 481, it can be reversed only if the evidence presented by Elias Zacharias was such that a reasonable fact finder would have to conclude that the requisite fear of persecution existed. That's kind of the traditional standard we apply when reviewing jury verdicts. We take the facts in the light most favorable to the victor, and we assess whether, as a matter of law, any reasonable fact finder could make the conclusion that the jury made. Elias Zacharias seems to suggest the same standard, at least in this sentence, seems to suggest the same standard as applies under the INA. Is that your position?
No, we disagree with that, Your Honor, because again, that sentence you just read from Elias Zacharias is correct as to what that case was about. This inquiry into causation, into the subjective state of mind of the persecutor, and whether the non-citizen feared.
Why wouldn't we apply that same standard under the INA? So we take the facts, here they're undisputed, we take them as given, and we ask whether any reasonable fact finder could conclude that that was persecution as a matter of law. Why wouldn't that be if we're going to do de novo legal review, why wouldn't that be the standard we would apply?
Because, for example, I'll analogize this case to fair use or antitrust conspiracies, which often go to jury verdicts like it did in Google versus Oracle. In that instance, Your Honor is correct. The reviewing court would construe the record in favor of the verdict, but it would not then ask whether any reasonable fact finder could have reached the result rendered by the jury. It would review the determination de novo. And that's because the inquiry involved in those instances, despite being record intensive, you have to look at the particular facts of the case. This court did at length in Google versus Oracle, for example. It's still a fundamentally legal inquiry, or at least a primarily legal inquiry under U.S. Bank. And we know that because, as again, decades of judicial experience.
Well, but the legal inquiry, again, with juries, it is a legal inquiry, but the inquiry is, as I've described it, it isn't, do we think this amounts to, on our own, that's usurping the fact-finding function, we say, of the jury. So we take all the evidence in light most favorable, and we say, could any reasonable jury conclude those facts are enough?
Respectfully, Your Honor, no, you did not do that in the fair use context, in the antitrust context, in Icicle Seafoods, where the question was whether the particular activities of a group of workers qualified them as seamen under the Fair Labor Standards Act.
I'm familiar with the antitrust context, and that's exactly how you review jury verdicts in antitrust cases.
The ultimate question of whether an antitrust conspiracy existed, whether there was anti-competitive conduct, that is ultimately reviewed.
Light most favorable to jury verdict, could someone conclude this violates Section 2? Could this violate Section 1? That's exactly how we proceed.
I don't believe so, Your Honor. And Google versus Oracle, I mean, that's a decision from this court, held the exact opposite. It said, we do not ask whether any reasonable jury could find that there was fair use. We determine we're construing all of the subsidiary facts in favor of the verdict, but as to the ultimate question of whether those facts demonstrate fair use under the law, the court did not ask whether any reasonable jury could have found fair use. It asked, do we, exercising independent judgment, find fair use?
As a backup argument.
Because I think that's what the First Circuit essentially did in this case. It said, we're taking the facts as given and we're reviewing the BIA's interpretation of the law for reasonableness. That's the inquiry that we are asserting in this context is incorrect, because the underlying question is a primarily legal one that should be reviewed de novo by a reviewing court. That's why the BIA itself, I think under that reasoning, should be deferring to the IJ on this question. The IJ is the one who sat through the evidence. They've heard the testimony in the record. They're closest to the facts. That's an inquiry that under U.S. Bank would say, if this is a factual inquiry or a primarily factual inquiry, we should defer to the fact finder. The BIA does not do that. It recognizes that the inquiry is primarily legal and it warrants exercise of independent judgment by the BIA as the appellate body.
It's primarily legal. Go ahead.
Putting aside what the BIA thinks, why is this primarily legal? If I understand the question here, we have this word persecution, and the question is, how do we apply it to certain threats? And there's a legal rule that says, well, a threat can be persecution, but only if it's menacing enough to cause actual harm. And that's the legal rule. A threat can be persecution, but only if it's menacing enough to cause actual harm. Now, what's going to happen in this case is we're going to have to look at all this evidence, all these facts, and decide whether these threats were indeed that level of menacing. And that sounds like really weighing evidence to me. That sounds really factual.
So we disagree with that, Your Honor, and I think for two primary reasons. I think the persecution inquiry in itself, persecution, that's not a commonplace word like are two people acting as strangers like in U.S. Bank, or are people going to have a hardship like in Wilkinson. It's a term of art. It's the product of a treaty that this country has signed.
We're not though going straight from the word persecution. We in fact do have what U.S. Bank might have thought of as a auxiliary legal principle. And that auxiliary legal principle is it counts as persecution if the threat is sufficiently menacing to cause actual harm. Now, the question in this case doesn't actually have to do with whether that legal principle is right or wrong, should be changed or not. The question in this case is just, were these threats that level of menacing? And that's really factual.
So I think just one quibble with the question, Your Honor. We actually do dispute the propriety of that legal rule. It's not presently before the court. But when we were stuck.
But as this case comes to us, that legal rule is that legal rule.
To an extent.
Then I'm just sort of thinking, then you're saying we have all this masses of evidence of what the threats were and who made them and, you know, how serious they were. I don't mean to belittle that. That's an important question, but it's a factual question.
We disagree with that, Your Honor, because
it's a primarily factual question. You're obviously applying law to a set of facts, but what you're going to be doing in the way that the U.S. Bank opinion lays it out is really getting into the nitty-gritty of what the testimony is about what happened.
That's true to an extent, but I think the same thing is true in the fair use case. I mean, this court's opinion in Google versus Oracle was looking at the nature of declaring code. It got extremely in the weeds. Credit to Justice Breyer for doing that. But it's still involved, like any mixed question is going to involve a close look at the factual record. But I think what the inquiry in U.S. Bank calls for is asking, number one, is this standard something that people have of an ordinary common understanding of?
Can you babysit for just a second?
No.
I gotta.
And in addition to that, applying this standard is the stock judicial job just to say, oh, persecution, let's look at the facts and determine whether it's persecution. That's not what's happened in the lower courts, and the government doesn't dispute this. Lower courts have developed a slew of auxiliary legal principles related to threats, as Your Honor pointed out, but in a whole bunch of different areas, religious persecution, sexual violence, I could go on. And what U.S. Bank says is that when that is the case, you don't necessarily look at any given case that comes before the court and say, look, is this a boring case that's kind of run of the mill, or is this a case that raises some really interesting new issue? No, when courts are developing auxiliary legal principles, all decisions about that mixed question are reviewed de novo. We don't look at a fair use case and say, is this a boring one, or is this a really interesting one presenting novel issues? And I think that's the problem with the government's position. I do want to say one thing. To the government's credit, they've made, I think, a significant concession here that departs from the status quo in a lot of circuits, is that they have at least acknowledged that courts owe no deference to the BIA in interpreting the law, at least in some kind of purely legal sense, and in developing these auxiliary legal principles. And I think were the court to announce that and reaffirm it, with a megaphone, I think that would do a lot of good, and it would change how a lot of circuits address these cases. And we think in our case, it would warrant a remand.
Not for the government. This is the petitioner's attorney.
Mr. Rossellini, do you think that in every instance in which a legal standard, no matter the degree of concreteness of the legal standard, is applied to a set of facts, that the ultimate determination is a legal question?
No, Justice Alito, we don't think that. We think that under this particular statute, when that inquiry looks a lot like an admission eligibility decision or an asylum entitlement decision, but isn't one of those like we have here, that's a situation where, yes, the application of law to fact would be de novo.
My question is similar to Justice Kagan. So the definition of persecution that was applied by the IJ here is, based on First Circuit precedent, is that it must add up to more than ordinary harassment, mistreatment, or suffering. You may have a set of historical facts that are undisputed, but determining whether they add up, whether the totality of those facts satisfies that standard, sure looks to me like primarily a factual question. Why is it not?
Because when courts make that decision, they're building out a body of decisional law that guides future cases. If you look at the First Circuit's decision in this case, the IJ's decision in this case, they are analogizing to cases
That would
came
be true
before.
in the vast majority of situations. Do you think the determination of whether of negligence is a legal standard?
No, Your Honor, we would agree that negligence would be something that's reviewed deferentially, but I think there's actually a
But
helpful...
every case where negligence is found or not found could be said to build out a body of precedent about whether negligence was shown. Why isn't this similar to that?
Because I think negligence, number one, the inquiry there is basically what should a person have done given the circumstances? The light was red, should they have braked or accelerated? People have an ordinary sense of that. I think the negligence example is a helpful one because you can contrast it with the duty of care inquiry, which, and as you know, as this court well knows, duty is traditionally for the judge.
That's a good answer.
Negligence is for the jury. And in the duty context, you do have to get immersed into the record to establish whether there was a duty of care. But if you ask someone on the street, hey, was there a duty of care in this circumstance or that? They're not going to be able to answer that as readily. And courts build out, again, a host of legal principles for different kinds of situations in the duty of care context. And that's what happens when courts apply the persecution standard. They're taking a term of art that's not commonly understood. They're building out these legal principles that courts can then apply and flesh out. Yes, at this kind of medium-high level of establishing auxiliary legal principles, as Justice Kagan was explaining, but then also refining what those auxiliary principles actually mean on the ground. What does it mean for a death threat to be sufficiently menacing to qualify as persecution or not?
This is an amazing
decisions
answer.
in this case, like in so many others, are looking to these prior decisions to figure out what is the mode of analysis that is applicable to these facts. And if you go to many circuits, in fact,
I don't know
to
who
help their
this
staff
is,
attorneys and law clerks have these
but I
very
would hire
detailed
him.
outlines explaining prior decisions that came before, so that it helps them assist their judges in making correct and efficient decisions that can be squared with the cases that came before them. But the irony in this context is that a lot of those decisions, the ones that are at least denying relief, they're not holding that the BIA's decision was correct as a matter of law. They're just saying that it was reasonable. So you have courts, you have the agency, they're all looking for guidance on this question. They're looking for precedent to use in making their determination, but they don't have a clean set of precedent to do that.
I love how he's rounding this out.
And said, this is in fact the correct interpretation of persecution as a matter of law. And that is really the problem here. And again, courts are already doing the kind of inquiry that we're suggesting here under the Convention Against Torture. In most courts of appeals, if the facts are undisputed and the sole remaining question is whether those facts demonstrate mistreatment rising to the level of torture within the meaning of CAT, they review that termination de novo, and they're doing just fine. And that's correct, because it builds out a body of precedent that courts can use effectively for future cases. And that is the kind of judicial work that under U.S. Bank, we think would counsel in favor of de novo review. And it's the kind of judicial work that makes clear that this inquiry is not a finding of fact within the meaning of Section 1252.
Can I ask you a question about
That
how
was
the
a
BIA
banger.
reviews the IJ? Because that's a good point for you, but the government responds that the agency's decisions about how to structure internal review do not determine the standard of the review that courts of appeals should apply, which is determined by statute, constrained by the role of appellate courts, that they go on. But I want to get your clear response to the government on that point.
Certainly, Justice Kavanaugh. And again, we're not here telling you that the BIA's interpretations of these regulations dictate the meaning of the statute. But what's telling is that the regulation on which the BIA relies uses the exact same words as Section 1252b4. It says findings of fact. And the BIA has said that this exact inquiry is not a finding of fact. And on top of that, the BIA, despite recognizing that immigration judges are in the room, they're hearing the witness's testimony, they found the evidence, the BIA is still viewing that as something that it is institutionally better positioned to resolve, just like a court is.
Thank you, counsel. Justice Thomas? Mr. Sotomayor?
Counsel, you did not challenge below the legal standard that the First Circuit uses, right?
Not explicitly, Your Honor. We've obviously resisted the finding of persecution here. We think that argument...
But you didn't say that they've used the wrong definition. I actually don't understand why a credible death threat would not always cause suffering or harm, and the other side will respond to that. But you didn't say that. You've been arguing something quite different.
We did not make that argument explicitly before the First Circuit. I think it's fairly subsumed in the question of whether do these facts as they are demonstrate persecution. And again, on remand, we would make that argument.
As far as I understand the government's position, if you had challenged the standard, they would say that's a legal question that the court would have looked at. Because you didn't, you were actually arguing the facts, that these facts showed enough suffering or harm. I think that's their position.
I do think that is the government's position, but again, below, we were up against.
Do you lose if I accept what the government says?
No, Your Honor, because in the First Circuit, they cabined their review entirely to deference to the BIA, and like many other courts of appeals, they have not taken the same position as the government that a question like that would be reviewed de novo.
You're saying we have to look at that question.
Correct.
We have to decide that.
Not in the first instance, but remand so that we can advance it. Maybe the government has a waiver argument. Maybe they argue that we didn't waive it because there was First Circuit precedent on point, but we need to go on bonk. We'll have that fight on remand.
I mean, what do you think, Law? Should they be able to de novo review this?
Yes.
I'm not sure
I agree.
understand your argument about Elias Zacharias, because I think that's, I came in thinking this is a strong argument on the government side, so I want to understand why you don't think it is. But if I look at Elias,
I find that activist judges are questioning him a little more than I thought they would.
We're going to provide
interesting.
deference here because, you know, you know the footnote I'm talking about, right?
Yes.
I can't find. And then the question that they're providing all this substantial deference on is this. It's whether a guerrilla organization's attempt to coerce a person into performing military service necessarily constitutes persecution. So I don't get it. That seems like at least, that seems a very similar question to this one, and they're providing substantial deference.
Well, 2 points there. I think the question that Your Honor finished with of whether there's like a categorical rule that something would qualify as being on account of persecution. I don't actually think that the court deferred to the BIA in that regard. It analyzed that legal issue for itself. But the underlying question of what was in the persecutors' heads, why were they doing this? That is a classic finding of fact. And again, the statute that Elias Zacharias was analyzing, like this one, did not say.
You're saying that the only thing that Elias Zacharias deferred to was an underlying finding of fact, as opposed to the application of a legal standard to those facts?
I think that's right, Your Honor, because
Nicholas
again,
Rossellini is the counsel of record. I think that's who this is.
Clear is that the statute makes motive central, and what the non-citizen had failed to do in that case was come forward with sufficient evidence to compel the conclusion that the motive of his alleged persecutors was on the basis of political opinion. That was the core, that was the molten core of the dispute, and the court correctly viewed that as a factual issue going to state of mind, and it reviewed that deferentially.
Okay. Justice Gorsuch? Justice Kavanaugh?
So I think you're saying Elias Zacharias was written more broadly than it needed to be, because as written, it is broader than that.
I think there are a few lines that are a little bit more broad, but again, I think that's exactly why this court has cautioned multiple times. We do not read judicial opinions like statutes. We take them in context. We look at what was the actual question presented.
If we read those lines as written, that's a problem for you.
I think it would be a problem for us. But again, we would encourage the court not to read its opinion like a statute, but read the statute here like a statute. And that's where the government.
Second different point, on pages 4 and 40 of the government's brief, as you point out in your reply, they make this, you call it concession about legal arguments. Do you have I'm going to ask them this, but do you have a sense of how that's going to apply?
I think it's going to be tricky. I mean, again, I do want to commend the government for making that concession, because that is not how many courts of appeals are viewing this issue. They are deferring to the BIA on those kinds of questions. We've cited some cases in our reply brief doing just that. So this court, again, takes.
Your point is that the government's brief is asking for something new as well?
That's correct. That's correct.
Well, we'll ask them about that.
Okay.
Thank you.
Justice Barrett? Justice Jackson?
So as I understand the history of this B4, Congress added it to the INA when it enacted ARERA in 1996. And prior to that, I understood that courts were applying deference, substantial evidence review to this asylum eligibility question. So if you're right that Congress was silent as to what is supposed to happen with asylum eligibility, I guess I'm trying to wonder whether we shouldn't believe that Congress wanted the pre-existing practice
If you're
to
coming
continue.
in, this is a case
No, Your Honor,
dealing
that
with
pre-existing practice was
asylum
not,
and persecution.
with respect, as Your Honor described. It's true that some aspects, like motive, as was at issue in Urias-Zacharias, were reviewed deferentially, as they should be, as they still are today. But if you look at the actual component of the asylum eligibility inquiry that is at issue in this case, what rises to the level of persecution, that inquiry, the government has a extended string cite on page footnote 2 of its brief, and those cases are not, by and large, not addressing that issue. They're addressing other issues. They're just referring to.
All right, do you have a corresponding string cite of cases pre this provision?
Yes, in our reply brief, forgive me, the page numbers is escaping me, but we've cited a couple of cases that go the opposite direction. And the point here is that the government asked you to grant cert in this case because they agreed with us that the courts were so confused about the appropriate standard of review as to this narrow subcomponent of the asylum eligibility determination. I think it's with respect to my friends, it's a little bit rich to say that confusion that is so entrenched and significant that they supported cert in this case can somehow be resolved on a snapshot consensus at a given point in time. That's just, that consensus did not exist.
All right, one more question. Going to the kind of overall thrust of your argument, it would be to enable courts to consider this de novo and particularly and possibly override the BIA's determinations. And I guess I'm wondering how that's consistent with what we understand the general thrust of Congress's amendments and the thrust of IRERA to be, which was really to limit.
She's got to stop saying thrusts.
So many thrusts.
So many thrusts. It's usually a good
So
thing,
it seems
but
like this would be a little discordant with what Congress was trying to do here, right?
No, Your Honor. Point number one, asylum has actually been kind of like singled out for special treatment by Congress. If you look at Section 1252A, even the discretionary determination about whether to grant asylum, that's judicial review over that determination has been preserved, even as Congress stripped away judicial review of most other discretionary determinations. And I think what that tells you is that even as Congress of course, was limiting judicial review in many respects, it viewed asylum as different and something that needed to be preserved in significant part. And I would also just come back to the fact that we're not vouching for a change here. We're saying that Congress crystallized in Section 1252B4 what had already been the case, is that a determination about whether undisputed facts legally qualifies as persecution is not a finding of fact. Those words, they were in place before era, they're in place now, and the plain meaning of those words does not encompass this determination.
Thank you.
Thank you, counsel. Mr. Dos Santos?
that was quicker than I thought. Come on, baby
Thank
girl.
you, Mr. Chief Justice, and may it please the court. Let me just start by picking up on questions about like what the inquiry is that the BIA is making here and what our position is on what the standard is here. So the courts of appeals have broadly agreed that persecution means really extreme suffering. So you kind of plug that in, kind of like the court did in US Bank. So what the agency is asking here is, looking at the evidence that the petitioner has provided, is this extreme suffering? How much suffering has there been? And that is a question that requires lots of weighing of facts and drawing of inferences. So like in this particular case, just look at the facts here. So on the one hand, petitioner's half-brothers were shot because of a dispute between their father and the half-brother's father and a Sicario. But then on the other hand, his mother and his stepsister and his stepfather were never threatened or harmed. The half-brothers appear to have been fine when they moved away from the hometown. Petitioner appears to have been fine when he moved away from the hometown and he lived for years in peace in other parts of El Salvador.
The second move. I think that was the second
talks
one.
about the threats, but on the other hand, the threats demanded money. So what do you infer from that? Was it just intimidation? Were they even connected with the Sicario? I mean, these are all questions of the kind that go to juries. The juries draw inferences. They can cut in different directions. You have to weigh the facts and inferences. What we're saying here is Congress wanted substantial evidence review to apply so that there is deferential review of that weighing of facts and inferences by the agency. And we think it's very clear for several reasons. Let me just do 3 quick points. One, we think the text and the history point exactly in that direction. So one, Congress in Section 1158 talked about the question as one that is factual for the trier of fact. Two, this court in Urias-Zacharias beforehand had said that that was a factual question and applied substantial evidence review. The courts of appeals had all done that. And then the substantial evidence provision at issue here codified language from Urias-Zacharias. So clearly Congress was aware of it. There's no way, no realistic chance that when Congress was overhauling standards of review in IRIRA and affirmatively overturning what courts of appeals were doing in certain respects, and then codifying Urias-Zacharias, that it was either unaware of that practice or silently departing from it.
Says an attorney who will make an argument next week or something that Congress didn't know what the hell they were doing. Just appreciate the irony
that the court
here.
uses across a variety of contexts points in exactly the same way. The work being done here is primarily factual, and just last year in Wilkinson, this court applied that approach to the INA and said that application of extraordinary hardship.
Let me be clear about what happens.
Inquiry that is subject to deferential review. And the last thing I'll say is petitioners' contrary arguments, they really kind of
Laws
all boil down to the
Magesti,
idea
nobody talks shit
that
about him or you get
every
blocked.
mixed question in the INA is going to be subject to de novo review. I think this court, both in Guerrero-Lasprilla and Wilkinson, said that wasn't going to be the consequence. And I think that would be a sea change and irreconcilable with IRIRA. I welcome it.
Thank you, counsel. I'm sorry.
No, that's okay.
Your friend began the argument by saying there were not, in fact, factual determinations. What precise facts do you think would be necessary to resolve?
Got rid of Chevron
the
deference.
ultimate fact is the one that's at issue, is how much suffering was there. So, for example, I'll point the court to like the decision in TSC Industries about materiality. There are all kinds of situations in which juries get a question like, was the statement material, or pain and suffering, or negligence? And you have historical facts that could be undisputed, like here there were these threats and we know what was said. But then what do you infer from that? How much suffering was there? How do you balance the fact that he was fine when he moved away from his hometown versus the fact that he was threatened several times and the threateners asked for money? And that kind of weighing is one for the BIA. Now, if petitioner succeeds in the argument that no reasonable fact finder, no matter how you weigh the evidence against him, no matter what inferences you draw against him, no reasonable fact finder could have found that there was no persecution, then he would win under substantial.
Isn't that a legal question?
That question, when you draw all of the inferences, and that's what we say should be done.
So that's a legal question that judges can review under that pre-existing standard that Urias-Zacharias speaks of.
That's correct, and that is our position.
And also you concede on page 40, as Justice Kavanaugh pointed out, that if there's some dispute about what the term persecution means as a matter of law, that a court can resolve that de novo.
I can't ever tell the difference between Alito or Gorsuch, so y'all on your own with that one.
That's Gorsuch.
How that would work. I think this is very similar to what courts of appeals do in all kinds of contexts, and in fact what they are doing under the INA. So think of the example of a district court. There are all kinds of decisions that district courts make that are subject to abusive discretion review or clear error. And all the time litigants come and they say, okay, so here are my arguments on abusive discretion and clear error. But setting aside the way that the district court cashed out my particular facts, the district court used the wrong standard. And that is a legal question, and you have to correct the legal standard de novo. And the courts of appeals distinguish those things all the time.
Would I be right, Mr. Dos
so
Santos,
much.
to say that I could say the same of your position that you just said to Mr. Rossellini? You said he would have every mixed question turn into a de novo question, but would you have every mixed question be given substantial evidence review?
No, Your Honor, I think you could look at the way that this court talked about it in U.S. Bank. Not all mixed questions are alike.
So what kinds of mixed questions would not get substantial evidence review?
That's a good question.
With respect to what? I'm sorry?
These matters.
So I don't have any examples to give you in that respect. I think a lot of what is done is going to be
Really
factual
not bringing
in the
their A game
immigration
here.
space. if there are legal questions that turn on interpretation of a particular definition, like a reticulated definition, and the primary work being done is interpreting.
I would have figured the
looking
government
at
would
a
have put their best
statute,
people on
looking at
this
structure,
one.
looking at legislative history and so on, which is not what's at issue here. I mean,
Is this
then it's
DeSoto?
primarily factual. The other thing I'll say
what
is
is
one of
his
our arguments is that
name?
Congress treated this
It's
as
just something,
factual.
yeah, it may be
So if
DeSoto.
there were evidence that Congress treated something else as more legal, then that would cut the other way. But I mean, here, if you look at Section 1158, Congress
I
said,
don't get that argument, I have to say, Mr. Dos Santos. Because
Dos Santos.
you have some good arguments in this case, but honestly, none of them come from the text. You have a good history argument.
That may have been what you said. It's hard for me to hear.
The Urias-Zacharias case. But 1158, just because we call an IJ a trier of fact, you're going to read that to determine what the standard of review is?
so several.
I mean, if you just said that we don't give substantial evidence review to legal questions, if we took your textual arguments seriously, we'd have to give substantial evidence review to legal questions too, because after all, 1158 calls the IJ a trier of fact.
So I think what we're saying about 1158 is the thrust of the way Congress thought about the refugee question, is someone a refugee, is that is primarily factual. And so the way that it described the way that an applicant sustains the burden, that's the title of the provision, to show that they're a refugee, was by saying that they have to satisfy the trier of fact, not only that their evidence is credible, not only that it's persuasive, but that it's sufficient to show that. And then goes on to say, and the way that the trier of fact does that is by weighing the testimony, weighing the other evidence. And that combined with Congress's codification of Urias-Zacharias, taking that same language and plugging it into the substantial evidence review provision, combined with the history before that, I mean, I think it all just makes clear that
Refugee eligibility is so much clearer than asylum eligibility.
The IJ is going to make that we want to have the Attorney General take care of. And then,
Did you
That's
say
what
at
I
the
was saying,
beginning
because
that
they're two
extreme
different
suffering
things,
is
right?
the essential standard here?
yes, I think every court of appeals essentially has said persecution.
Is that a legal question, what extreme suffering means?
No, I think that's the kind of inquiry that's going to just, you look at the totality of the
No, because then that's a question of
a concept that most
of
people
law.
can
Like,
grasp,
where is
and you're
it?
gonna
Where
have to, in each
is it?
case, just look at all of the facts and say, was this extreme enough? How much suffering was there here?
But I think that suggests that you really can never have cases that serve as precedents for others, or that the court is not actually developing law in the area. And that's my concern. I mean, I understand questions of fact that arise out of disputes over what happened. So if we had a situation, not this case, but if in this case there was some question about whether he was actually
I gotta get
threatened, the government had some evidence that showed that what this person who was seeking asylum said happened to him wasn't true. All of those things would be questions of fact that the trier of fact would be charged with determining. But then once we have the established body of facts, you move to another stage, which is determining whether or not this body of facts meets a certain legal standard, whether it's persecution or some other standard in this area of the law. There are many legal standards in immigration law. And I guess I'm just concerned about the suggestion that in this second stage where we have settled on the facts and we're deciding whether or not, or the agency has decided whether or not the legal standard is met, that we're somehow now in a world that is not a question of law.
So that's because, like this court has said several times, when there's a mixed question, it's not just the historical facts. It's what inferences you draw from them and how you weigh them. And that's traditionally the province of the jury, like this court said in TSC Industries, where the court said it's not proper to do summary judgment for the materiality question when, even if you take the historical facts, there's going to have to be inferences drawn and weighing. And the other thing I'll say is that it's not the case that the legal principles go totally undeveloped. I think that's totally belied by experience over decades. There are lots of times when courts of appeals in the course of applying substantial evidence review will either say, one, petitioner wins, so as a matter of law, no matter how you weigh this, then you have this rule of law. But also in the course of saying that, they'll provide broad guideposts. Like, for example, in general, mere threats are usually not going to be enough.
Well, could we develop the law too, as we do with jury verdicts, and say some set of facts cannot be reasonably by any fact finder reach the conclusion of persecution?
That's right. So it's exactly in the same way that you would review a jury verdict.
The law that way.
That's right.
But what about the very limited circumstances that our friends on the other side point out, like fair use doctrine under the copyright statute, that we will review de novo without that kind of gloss?
Yeah, I think the court has said that when the background, I should say, just to back up to sort of make clear what the inquiry is here. In the U.S. Bank, sort of how do we decide which bucket of standard of review to put something in? There are a couple of different important considerations. The lodestar is what kind of work is there, primarily factual or legal? But then there's also, you consider the background, what's the tradition been here, and whether it's constitutional or not. With those kinds of questions, the ones you're referring to, I think the court has looked to, the history of this is that it developed de novo in like a common law sort of way.
In text history and tradition.
Right, it developed that way. And so if Congress has then talked about it, we presume that, Congress was treating it that way. That's not the case with these kinds of determinations. The tradition cuts exactly the opposite way.
I'm a little confused by your answer to Justice Gorsuch. You said
everybody
a definition of persecution could be a legal error if that's what they were challenging, correct?
That's right.
All right. So here, if they had said, why do you need to show suffering at all? If it's a death threat, why isn't that standing on its own suffering? The threat itself doesn't cause you suffering or harm. You see your mother or your father killed in front of you. You suffer from their death, but you're not suffering from the threat.
So, as petitioner, I think, admitted, they didn't make that argument about the legal standard. So the only question was applying the First Circuit's own precedent.
So in answer to Justice Gorsuch, you then said that it was a legal question of whether any reasonable fact finder would have said this was not prosecution. And you said that's a legal question, correct?
Applying the standard that the circuit had already announced, yes.
Yes. So I think what the other side is saying is the First Circuit, I'm not sure what they're saying, whether they're saying the First Circuit didn't apply that standard at all.
No, the First Circuit definitely applied the standard. Everybody applied that standard from First Circuit cases. The IJ, the BIA, and the First Circuit itself.
No, the standard being that no reasonable fact finder could not find this. Every reasonable fact finder would find this persecution. It's a little easier to put it in the positive rather than the negative.
I think petitioner agrees that the First Circuit applied that rule, which is substantial evidence, which is Urias-Orellana.
Thank you.
Why does the BIA review these kinds of questions de novo?
Yeah, so I think understanding what the regulation actually says, which is different from what my
I'm just
friend...
curious why.
So if I could give you a little background, it'll make more sense.
The underlying rationale is for that.
Yes, I think the history is very helpful here.
Appreciate the sassy.
So before 2002, the BIA was reviewing everything de novo, including facts.
I got the history. I'm just what is the reason
that
makes sense?
So
why, like Judge Collins said, why something that's treated as a question of law transforms into a question.
So here's where I was going. It's not that it's a question of law. What the regulation says is we're going to stop the de novo thing. We're going to do clear error for facts, but we don't want that to mean that judgments and questions of discretion are not subject to de novo review. And it said judgments include decisions about whether the applicant has shown past persecution.
That's telling me what the regulation is. I'm still trying to get it.
Yeah, well, my answer is because it's a question of judgment, and both the BIA and the IJ share the responsibility to exercise.
He's getting a little uppity. I'm just saying.
Because judgment is the question about weighing
context.
So the question about weighing facts and determining whether it's persecution is going to involve judgment, and both the BIA and the IJ have expertise in looking at recurring fact patterns and seeing all kinds of
hello Loper, right?
These cases, far more cases than any.
I was wondering when that was going to come.
And as this court recognized in Ming Dai and Orlando Ventura, in many cases, the agency has expertise here to apply to deciding those questions.
Oh, but do they though?
AG
But
decided,
do they?
We'll do clear error, but I'm going to reserve more review for these judgment questions. That doesn't mean that Congress wanted courts of appeals engaging in that kind of judgment in the first instance. And as was already said and admitted, the way that the BIA engages in review, the way that the AG designs internal review has no bearing on that. For example, the BIA reviews questions of discretion
Listening
de novo.
to
No one thinks the Court
the
of Appeals
case
should do
above
that.
me.
It reviewed facts de novo before 2002. No one thinks the Court of Appeals should be doing that either.
If we repeat what you write in your brief on page 4, do you think the lower courts are already doing that? Anyway,
Yes, I do. I think they were doing that before IRIRA. I think they're doing that now. I think it's standard practice where if a petitioner says, look, regardless of the way my facts cash out, the BIA stated the wrong standard and used a standard that's incorrect. That is a question that courts review de novo.
And to show that the standard is incorrect, again, on extreme suffering, what would you have to say? We think extreme suffering is too high a bar.
So there have been questions that have come up. So like one that happened earlier was, is evidence that there's lots of crime in my country and I'm very likely to be a victim of crime, is that relevant to persecution? And the court said, no, that's not relevant to persecution.
That's a legal question.
So like, is it ever relevant, right? Is it ever going to be relevant to persecution? Legal question. It's not like, look at the facts of my case. It's like, this is the standard. And there are other questions like that where questions about whether the standard should be lower.
He's really circling the toilet bowl here. I'm really hoping he's going to step up his game.
So
I'm
the
not
other
gonna
thing I
lie.
just want to emphasize is that this court in Wilkinson really already talked about this some and cited the U.S. Bank sort of formulation and said, and applied it there and said, application of the term extreme hardship, which is kind of very analogous to the question of extreme suffering, that is going to be something that is primarily factual and reviewed deferentially. I think the petitioner's contrary arguments are really saying the thing that this court was resisting in both Guerrero-Lasprilla and in Wilkinson, which is that every mixed question, no matter how factual it is in the INA, is going to be subjected to de novo review.
We're
I mean,
saying
that really would
primarily
be a sea
factual.
change,
Of course, what
and it's
you're
really
reviewing are
irreconcilable
the
with
facts,
IRIRA.
but
The other thing that
you're
I'll note, as
reviewing
Justice
them
Jackson
to
pointed
agree
out,
if they're
I mean, the
coming
thrust
to
of
some
IRIRA was
sense of like
Congress was coming in
persecution.
and overturning things that
I
courts
don't
of
know.
appeals were
This is
doing.
bugging.
I don't think there's any realistic chance that you could look at IRIRA and think that Congress was silently departing from the substantial evidence review consensus for persecution questions and asylum eligibility generally in adopting IRIRA. Unless there are any further questions.
Mrs. Thomas? Mr. Kavanaugh? Thank you, counsel. Mr. Rossellini, rebuttal?
Thank you, Mr. Chief Justice. Just a few points. The first one is that our position is not that every mixed question in the immigration context would be reviewed de novo. Under the text of the statute, our argument is only that mixed questions that resemble the determinations at issue in C and D, admission eligibility and entitlement to asylum, would get de novo review, because if the language Congress could have used is right there if they didn't use it. We think that inference is strong as to this particular question, but other things such as equitable tolling and Guerrero-Lasprilla, other kind of docket management determinations, for example, those would be reviewed for abuse of discretion. Of course, if the government came in and tried to say that those are findings of fact, we would again disagree, but we wouldn't dispute that they're entitled to deference, just a different kind. And then if you are looking beyond the text just to U.S. Bank, that analysis is really limited to just this particular mixed question at issue here. And as U.S. Bank, makes clear, the court has to look at each particular mixed question that comes before it and make the call. So that a decision on those grounds would be even narrower. I think it's telling that the government couldn't come up in response to, I believe it was Justice Kagan asked, would any mixed question in this context get de novo review, and they couldn't name one? I think that's because if this one doesn't get it, it's hard to think of an example. Persecution, again, it is a term of art. It's not something that ordinary people understand right off the bat. It's the product of a major international treaty. And we have decades of experience where courts are coming up with the exact kind of auxiliary legal principles that U.S. Bank talked about as a marker of a mixed question that deserves de novo review, even though it can, yes, some aspects of the decision can be fact intensive. They involve a close look at the record, but courts are also doing what courts do when they analyze this mixed question, and that's what separates this particular mixed question from others. Second, Justice Kavanaugh, to your question about the BIA regulations, the government is trying to couch this determination as a question of judgment versus law. They don't cite anything for that. We have BIA decisions calling it a question of law. But it really doesn't matter because the fundamental point is that the BIA agrees that it's not a finding of fact, which is the exact language we have in this statute. And the BIA agrees that the IJ's institutional advantages of being closer to the evidence don't justify deference to the IJ on this particular question. So this debate about judgment versus question of law, it's just immaterial. Fourth, on Urias-Zacharias and the history, Justice Jackson, your question, if you look at page 12 of our reply and note 2, we cite examples of cases analyzing this exact mixed question that predate era that were reviewed de novo. The case law, as it is now, is a muddle, so I'm not going to pretend that there was some consensus going in our favor, but we don't need to show that. The government's trying to tell you that there was a consensus that was somehow overruled by Congress. That's not the case. And on Urias-Zacharias more broadly, we would just reiterate that the actual dispute in that case was about motive. It was about a subjective state of mind, and the decision needs to be read in that context. And if it's read as the government says it is, number one, the government concession doesn't make sense because Urias-Zacharias, if you take a couple lines at face value, says the entire asylum eligibility determination must be reviewed deferentially, but they're admitting that even legal questions or even some amount of mixed questions about these auxiliary legal principles are reviewed de novo. So that just can't be right. And we think trying to draw that line about where do interesting cases that are creating auxiliary legal principles, where do those end and where do the fact-intensive ones start? You just can't draw that principle line. And this court has never tried to do that when it's analyzed other mixed questions, like in US Bank, like in Google versus Oracle, and other cases. But finally, even if the court does try to draw that line and accept the government's position, it's not the case that courts of appeals are doing what the government says is correct. Some are, but some are not. If you look at page 3 of our reply brief, we cite a 10th Circuit decision and a 4th Circuit decision that said, look, we acknowledge that the BIA has created this legal rule, but the 10th Circuit said we can't disagree with that legal rule unless we can overcome the
government
substantial evidence
creates
review.
A lot of
and the 4th Circuit ultimately disagreed with the BIA, but only because
Supreme
it found
Court
that
doesn't
this
vibe with.
Requirement of showing significant actual harm was manifestly contrary to law. So it too was deferring on what even the government admits is a legal question that should be reviewed de novo. So if the court, even if it sides with the government here, we believe that is an important change. It's clarified the standard of review that will matter going forward, and it should matter in this case, and we should be entitled to a vacator of the judgment below, at least on those narrow grounds.
Thank you, counsel. The case is submitted.
Okay, well, that case was like way quicker than I thought. Law, thoughts?
Yeah, I think, what may be a fatal error on the part of the petitioners was that they weren't, that they didn't preserve the objection to the standard that was used, the legal standard, which, given the fact that it was coming out of the First Circuit, which had already kind of affirmed that, it makes sense. But, and I doubt that this attorney, represented the petitioners at the first stages. But whenever you're in, trial court, or in this case, an immigration court, you want to preserve any objections that you can, any reasonable objections. I mean, there's some point where it becomes excessive and burdensome to the court, but that's one thing that may have been helpful to preserve. And I think that the more liberal justices were kind of saying there, especially Kagan, that, hey, you should have done this, and then this would have been a slam dunk for you. But given the way that they were trying to navigate the case through the system, it made sense. But at the end of the day, like the BIA, the Board of Immigration Appeals used to review everything de novo. And so, that's a de novo review. I should probably explain some of the standards of review here. De novo review means that the judge is taking a fresh look at everything, that they're pretending like the first court appearance didn't happen, that the first trial, or in this case, hearing, didn't happen, and we're looking at everything with fresh eyes to make your case as if it was brand new. That's a de novo review. and then there's other forms of review where you're reviewing for judicial error, where you're looking to see if there was sufficient evidence to reach a decision. The sufficiency of evidence. Those are the different types of review available. But what the court started doing, and largely because that there were so many asylum cases that were coming in, is deciding that that these are this is a question of fact, and we're putting faith in the fact finder as far as that. So then when you're talking about questions of fact, you kind of have three buckets that they fit into. One is a purely legal question, and appellate courts will always review legal questions. That's their job. The other is it a pure factual question? And they don't review pure factual questions. They put faith in the trier of fact, whether it's a judge or a jury, they had the clearest look at the factual questions. Yes.
Can you just like an example, just a simple example? What would be a question of law? What would be a question of fact? Do you have?
Yeah. So if a question of law would be like that, hey, even if you accept the facts that were presented at trial as true, they don't meet the elements of the crime. So if I have somebody who's got a disorderly conduct, one of the elements of law is that it has to have a likelihood of invoking unlawful action in the public or arousing alarm. And so if I look if a jury convicts somebody, but I say, hey, all they were doing was, waving a sign up on a public intersection. Yes, the jury convicted them. We're not disputing any of the facts, but we're appealing because the law was not properly followed. That becomes a question of law. Now, if I'm trying to appeal and say, well, the jury got it wrong because I wasn't, in fact, on that street corner. That's a question of fact, and the appellate court isn't going to review a question of fact. They're going to say, hey, the jury sat through the trial, the jury heard the cross-examination, the jury saw the evidence. We're not in a better position than they are to determine who was telling the truth.
Yeah, why didn't you bring this up the first time, basically?
Right.
Yeah, I got that.
Yeah, so you don't get to go to a appellate court and say, well, I disagree, because that wasn't true. That's a good way to frame it. If you're saying, well, they were wrong and that wasn't true, that's not something that the courts are going to look at. In this case, what we have is a mixed question. And that's where there's an element of law that requires heavily on the factual analysis of what happened. So in this case, this person was applying for asylum based off of past persecution. And you can apply for asylum for many reasons. One of them is past persecution, or one is a likelihood of future persecution. And if you can prove that you've suffered past persecution, then you can get your asylum claim. Now, what the court did here is said, hey, nobody disagreed. The government didn't disagree, and the petitioner didn't disagree that there was, that two of their family members were pewed, that there was a hitman that was out to get them, and things like that. So what they were saying was that this is not evidence of past persecution, and they appealed to the BIA saying, well, no, there is no dispute of the facts. They're not saying that none of that was true. They're just saying that these clearly meet the standard for persecution. And the BIA said no. And then further federal appellate courts said, well, hey, the BIA said no. They're the experts on this, and that's fine.
Well, one of the most interesting things about this case is, even though what I think happened to them was horrific, one interesting part of the government's argument that I did find interesting in sort of their finding that there was not this past persecution nor a fear of future persecution were three things. First of all, he moved for 2.5 years, didn't have any issues. He didn't until he returned. Second was that he never reported this to any of the police. And I can certainly understand that there are reasons in other countries why you may not do that, but it was never reported. And then third, the government was like, hey, you don't have any you didn't see a doctor, you don't have any apparent trauma, things like that. It was certainly one of those cases where obviously what happened to him was bad, but it was also odd in the fact that the brothers suffered this, but then they just kind of kicked him in the chest and asked him for money. So I could I could kind of see where the immigration judge was coming from, even though I don't necessarily agree with what it came to.
Yeah, but then I think that goes to show the importance of the ability to find relief on the application of the law,
Yeah.
because the immigration judge's rulings on that mixed a few different standards of asylum.
Yeah.
Is one was the past persecution, but then he's looking at it and says, well, he did move and he didn't face any adverse consequences. Therefore, there's not a likelihood of future persecution. But
Yeah.
that's a different
No, but
avenue.
they did both. Yeah, like they literally, when I was reading through it, yeah, they did both. So it was, like I said, interesting nonetheless.
Right. And so, in my opinion, when there is at least a colorable question that the law was not properly applied, it should always be a de novo review. And so, in that sense, I think they might find some sympathy, especially among Gorsuch and Coney Barrett, that well, there has to be a judicial avenue of relief when there's a question of law presented. What the state or the federal government was trying to argue was that whenever there is a mixed question, that should never that it should just be treated as a fact. Or I guess they were trying to attribute to the petitioner's position, which then they then said, no, that's not our position. Is that every appeal that has a mixed question deserves a de novo review. And I would say it at least has to have a high enough threshold that there is at least, more likely than not that the judge did not apply the law in the correct way. Then that should be earning of a de novo review.
Well, I'm so sorry.
No, you're good. No.
One thing I found really interesting, and they didn't bring it up more, and I was kind of sad about it, was sort of like their trajectory in Loper Bright, and even Carhill. Like, hey, the regulatory, like they went overboard. Like you don't get to do it this way. And I found it interesting that they didn't bring it up more. But
I think the reason for that is the federal government backed off on any sort of deference to the BIA. So they weren't saying that it was okay, that the courts have to accept the BIA's terms, because that would put them in conflict with their own positions that these are all deep state agents that have no respect for the rule of law. It would have put them in conflict with that. So they backed off on that, and they were more leaning on the fact that, well, this question didn't even reach that threshold that would have required the BIA's intervention anyway, because it was a purely factual question. So I think the reason why the judges didn't grill them on that is the government probably saw that coming and backed off from that argument and made that concession.
Their cert petition was so good. Like I'm normally kind of a little bored when I read those, but theirs was like they were quoting Scalia, they were throwing even some Alito decisions in there, and they were like, and because you said this in Loper Bright, and I was like, oh shit's getting real. So yeah, it was really good.
Well, and their reply brief was like, well, we're not relying on BIA.
Their reply brief was like 20 pages, and they were like, well, I mean, we didn't say that, but we kind of said that, but we didn't say that. It was great.
Yeah.
What do you think they're gonna do in this? I'm just curious.
From the questions, you really didn't get a lot. I didn't hear. Sotomayor got a little bit pointed with the petitioner. I don't think she asked any questions of the government. Coney Barrett didn't say anything. Roberts had a little bit of procedural questions. I didn't hear him asking much. Thomas didn't say dick. So it's hard to kind of divine what their thoughts are.
I can agree. I normally can get a sense, but this one was no.
Yeah, well, I think, and I think even the circuits, this was like a 3 to 4 or 3 to 5 in the circuit split. So even the circuits are kind of like juggling this.
Yeah, I think it was 6-5.
6-5. Oh, so even more.
It's a 6-5 split.
Every circuit has addressed this then. So so at least every circuit that would have seen it. Yeah, so that's as close as it comes. This is really a coin flip. I obviously I think that when there's at least a reasonable question, there should be at least be a reasonable opportunity to be heard, and that's what the petitioners are seeking. They want the denial of the appeal reversed with instructions on how to actually apply the standard, which is going to help everybody moving forward. And that's typically the kind of relief that I like, that at least gives guidance on what should happen in the future, rather than saying, aha, you didn't meet this checkbox on my little list, so we're just going to ignore this controversial question altogether.
Do you think if they do relief, it'll kind of be a little like very like tailored, right? Like to the specific question they're asking, but kind of like if this, then this sort of application, or just this is the way it is?
I think it'll probably be tailored to if they wanted to make it really narrow to not disrupt the whole asylum process, they would probably make it narrow to the decision of whether persecution whether the BIA's definition of persecution is something that's reviewable by an appellate court. So they're not even going to make a decision about whether this person should or shouldn't have gotten asylum. They're going to say, do this over again, and here is, don't rely on the BIA's determination in your review of the case.
And see, like, I think I'm in agreement with you that I think once this reaches an appeals level, like, they should be able to review this de novo. Like, I think there's a lot of application to this, and there's certainly reasons why, but like specifically with this question, I think just the term persecution, there's a lot of questions there, and it's not going to apply evenly across the board. It's not like a one size fits all sort of statement or measure. So
yeah. And I think it was Alito that brought up the negligence. And I thought Attorney Rossellini did a really good job of saying, well, negligence has like a defined standard that everybody understands, because it depends on the duty of care that from a reasonable person. Yeah. Like everybody knows, like if you're driving down the road and you're intoxicated, that is a breaching the duty of care. Nobody knows what the standard of persecution is. So to try to hold it as like as this measuring stick, our persecution language comes from our asylum, the asylum treaty from the 1950s, and it's not something that's developed in statute. There is no statutory language. So even when we're relying on that, we're also looking at a standard of a reasonable person will naturally flex as society changes. A reasonable person's duty of care in the 1800s is going to be different than a reasonable person's duty of care these days. If you're in a carriage and you're intoxicated, that's different than driving a vehicle.
Pour some buggy out drunk this weekend, y'all.
Yeah. It's like, you get pulled over. Are you drunk? Yes, but the horse isn't. So the reason that standard is going to shift, whereas the standard of persecution is going to very much be, yes, it's fact intensive, but ultimately there has to be some sort of a metric that has to be hit. And if you think that the judge did not apply those facts to that metric, that has to be something that has to be looked at with fresh eyes, unless there's like a clear statutory language that says, here's what persecution is. If it's that clear, which it absolutely isn't, then I could understand that you're only, reviewing for judicial error rather than, like a de novo review.
Yeah. I don't know. I don't know what the way they're going to go with this. I know I normally give the chat sort of my opinion, but honestly, I really couldn't tell you. I feel like they, like I had said it, and Lal repeat it, like kind of said, like they like jibed at the petitioner a little bit more, but I was kind of a little bit like, the more activists or what people term liberal leaning justices sort of like jibed at the petitioner more than I thought they would have. But I felt like they kind of very much questioned the government as well. So
and even then, it seemed to be. I felt like the petitioner had better responses to the questions that were posed than the government. When the government said that Yeah, DeSantis said that, well, I can't think of any mixed questions that wouldn't be entitled to
That was
de novo.
terrible.
I'm like, because I could think of some, and I'm much more aligned with the petitioners seeking relief in this one, and I could
can't
certainly think of
any, but that's on my job. So
right. Well, yeah, if you're there, these are like, I've done some appellate work, and when you're doing that, you like get with your attorneys. And I'm actually helping somebody who's going to be arguing before SCOTUS this term. We're doing a Zoom call, and each one of us has a role of one of the judges, and we've brainstormed all of these questions, all the justices, and we're asking them and we're grilling them these questions, and it's to help them frame their arguments and to kind of come up with this flow chart. If they ask this, here's what I'm going to say. That one would have been like number 3 on my list of, okay, they're going to ask you if these aren't entitled to, if mixed questions aren't entitled to de novo review ever, which ones would be and which ones wouldn't be. And I would have plans for each of those. Well, here's some that would be entitled to de novo review, and here's some that probably aren't. And he's just like, I don't know.
Oh man. Yeah, I think tomorrow, First Choice Women's Resources Center versus Plotkin. That'll be interesting. It's about where do the federal courts step in if there's some First Amendment fuckery. And then Olivier versus City of Brandon on the 3rd, guys. So
yeah, I think in the free speech one tomorrow, wasn't that one? I haven't read through all the briefs yet, but I think that one had to do with like, well, you were convicted of something, so now you can't get 1983 relief.
Oh, no. We already did that one. Already did that one. No, tomorrow's is interesting. First Choice Women's Resource Center is basically a anti-abortion clinic. Let's just call it what it is. It's a religious anti-abortion clinic.
Yep.
Plotkin slapped them with the subpoena and said, I want all your donors. I want this information. And then they appealed in federal, saying their First Amendment was being, squishied or chilled. And then Plotkin said, no, because only the state court can quash or enforce the subpoena. So it's a whole hot mess right now.
Okay. All right. I'm going to have to look into that one.
It's interesting.
Yeah.
And then, the Olivier versus City of Brandon is, that one may be the 1983 you're talking about, because it's about, where can they come in when he believes that the state, like they ticketed him for his religious expression or whatever, and then he did 1983 and where he can come in. 2 basic jurisdictions where the court's at kind of cases, but totally different things. So
excellent.
Anything else to add?
Nope, I gotta get ready. So thank you for having me.
Thank you for coming. We love to have you here, and everybody loves seeing you. They missed you. So come back, and we love law. Thank you for coming, and everybody have a great day. Bye, guys.